We're ready when you are, Council. All right. Sorry, you made yourself comfortable and we're just ready for you.
Well, it's been a while since I been before the board. Good morning.
Welcome back to.
Thank you. I'm Tom Whitaker Jr., representing Wendy's Auto Sales LLC. I would request 5 minutes for rebuttal be reserved.
Very good.
Basically, we're here today, since you're going to be reviewing this case de novo, to request that you perform the role that should have been performed first by the clerk, actually should have been done by the appellee's counsel, to see if in fact the substitute service statutes have been complied with, and they have to be complied with strictly.
If we agree that there was a waiver by virtue of appearance and actions in the case, does compliance with the statute even matter?
First of all, yes.
How
Yes,
is that?
because there also has to,
If someone is called and told, hey, you've been sued, there's going to be a hearing tomorrow, and they show up and they argue the merits, does it matter if they've never been served?
they have to have the equivalence of a general appearance and seek some kind of affirmative relief. Waiver is one thing. Seeking affirmative relief and constantly, being in the case and submitting yourself, because if you show up and are defensive in all your efforts, that's not going to constitute personal jurisdiction nor sufficient waiver, because the burden of proof, the threshold burden of proof remains with the person trying to effectuate service by substitute service.
Weren't you required to file an appeal of the various denials that were received versus the same motion?
No, sir. Cited in the papers that we filed. We could have really just waited.
How many times are you permitted to file the same motion, slightly different perhaps, and get a denial without being required to, you just keep going with the same motion? Usually trial court says, okay, I've already denied it, let's move on.
We literally still can wait and do this all over again on a plenary appeal. Because where there is on the face of the record, failure to comply with the strict pleading and strict perfection requirements of the Florida
Well,
statute.
wasn't it debatable? I think the gist of your argument is, well, they didn't have the magic words. They got substituted service for the secretary. They only alleged they couldn't find the guy. They only alleged the house was flooded out. They only alleged it was a new tenant. They only alleged so many things, but they didn't use the right words to say, couldn't be found despite diligent effort. You never had a hearing on whether that constituted diligent effort.
But none of those assertions, Your Honor, appeared in the complaint. The complaint has to contain on the face of the complaint allegations that trigger the substituted service statute.
And you disagree that you could have waived it by filing an appearance and arguing the merits once it was denied and not filing an appeal. You say you retained all your rights.
Yes.
Even though you didn't do that. Okay, I got the argument.
Can we circle back to the jurisdictional issues real quick?
Yes, sir.
You're not here on a plenary appeal.
That is correct. Where this is an interlocutory,
Right. So help me out then. How do we have, because we have to have jurisdiction really before we even consider the argument. How do we have jurisdiction over this interlocutory appeal of a ruling that was first rendered well before, more than 30 days before the issue was ever appealed? Help me out.
well, again, it's not waived. There's no requirement that the interlocutory appeal be taken at the first opportunity.
If you wanted to invoke our jurisdiction as an interlocutory appeal to consider in an interlocutory fashion, there is. Which is what you're asking. This is you are here on an interlocutory appeal of an arbitration issue, yes.
Correct.
You're trying to tag along the personal jurisdiction issue, but it's still an interlocutory appeal. And either you invoke our interlocutory jurisdiction or you don't. And that's what I'm trying to struggle with is
Right.
how, when the notice of appeal of the personal jurisdiction issue wasn't filed for well more than 30 days after that ruling was entered, how have you invoked our interlocutory jurisdiction?
Because the rule allows this appeal after the order that was entered on the motion to dismiss or grounds of lack of personal jurisdiction. that was timely filed. There's no waiver of the interlocutory appeal for not, when it was first raised in the motion to quash, when it was verified, and at that point shifted the burden over to the plaintiff to.
I don't think this is a question of waiver in the sense that you're using it. I think it's just a question of it's an interlocutory appeal. You have 30 days to file from the date of the ruling in order to revoke our jurisdiction, and if you don't have jurisdiction.
Well,
I don't
we
know
did
if it's a
file it
question of
within,
waiver. I mean, it's just,
but we did file within 30 days of the two orders that are the basis for the interlocutory appeal.
I understand that.
As a matter of fact, again, when a review on the face of the record fails to show there's been compliance, not just some of the compliance, but it has to be strict compliance with every one of the requirements. The pleading has to, on its face, cite something in the statute that triggers it. If you're a Florida resident, you have to be hiding.
I think we understand what the statute requires and what the pleading pattern doesn't have. We'll go back to the issue that I think is dispositive, and maybe my colleagues will disagree, which is whether or not the conduct in the case amounts to a sufficient basis for the trial court to determine you've waived any problem with jurisdiction. We're with service.
There was no, first of all, never saw anything in terms of any affirmative relief. Again, you have to go all the way to the end of this, and then as an additional defensive measure, there was a request to compel arbitration. But up to that point, there had been nothing more than just pure defensive. And we don't waive.
Default. Wasn't your client a default throughout?
Again, but it was an unauthorized default, Your Honor.
Did you move to set it aside on that basis?
Again,
Was it denied?
yes,
So the case goes on.
right. But again, at each juncture,
When was that motion filed to set aside the default? Was it before or after the issue of jurisdiction was raised?
after,
It was after.
but there was a motion to quash service of process in which it cited, and really before that, there was a motion to prevent discovery because they were trying to set depositions when they hadn't obtained service yet. And so in that motion to prevent the discovery, alleged they haven't served her yet. They don't have jurisdiction. They haven't triggered the entitlement to discovery. So at every point after the first day filing the notice and then a motion to continue the hearing 72 hours later on the hearing to enter a final judgment on the defective default, again, the clerk, and again, I'm not trying to put the clerk in any bad light, but the clerk was not authorized to enter a default because of looking at the record, and you see the only service there.
We're not here on that. I understand your dilemma, but what is the effect of the default on the record? Doesn't it admit liability? Once liability is admitted, the only thing left is damages. If you set aside the default, you're kind of stuck.
Unless you raise the fact that there is no jurisdiction. That default does not take the place of the plaintiff meeting its burden of proof to show that the very first step of this is that the plaintiff is obligated to show in the face of the record that number one, they pled.
What case do you cited for that proposition? What's your best case?
Oh my, there's.
If you can't find it, don't go crazy. I can.
Yeah, it's replete. I mean, there's a second DCA case in dealing with others. There's
Okay, move on, because you start to sound like when I was a trial judge, they say, Judge, there's plenty of cases, you can look it up. I say, it's not my job, so I'm not gonna look anything up as it's sitting here, but I'll take a look later.
yes,
But
no,
don't get off track of your argument.
right. Well, no, again, step number one, when you deviate from personal service, then you come under the penumbra of having to trigger the statutory means of substituting some other way to get somebody in the case. And the case law, I mean, it goes back to at least the 70s. I found precedent in this district, and in which there's Supreme Court authority even cited that you've got to not only plead it, that's to trigger it, but then you've got to perfect it. And there's 3 requirements for perfection. You have to send a copy of the process showing that the Secretary of State's been served to the last known address of the defendant. Number 2, you've got to file a copy of the return receipt or registered mail efforts that it was sent, delivered. And then thirdly, and here's perhaps one of the biggest elements that are missing here, there has to be an affidavit filed by the proponent of substituted service saying that the statute's been complied with. There are cases where if it was filed 12 days late, they found no personal jurisdiction because of failure to have substituted service. That's how one case, it was an $8.3 million judgment that had been entered based on a default. And they found there was no substituted service. And they went through 3 different attempts to effectuate that. The first time around, they failed to plead it. The second time around, they failed to show that the affidavit had been served. It was filed late. In this case, there was absolutely not one element of the strict compliance of these statutory requirements met. Not a single one. There was no engagement on that issue at the trial court level at any time. And in the answer brief, again, there was no engagement. I mean, the substituted service statutes were not even cited in the table of authority. So there's never been any discussion, and until the plaintiff meets that burden, there's nothing further to discuss because on the face of the record, there's no service. So if the court has no, there is a second issue on appeal. However, and what we're requesting is that you again find that they never had service and therefore everything has to be set aside and we're back in the game. On the arbitration issue, that was put in there as a final defensive effort because the parties had agreed that they would rather go to arbitration if one of them elected to do so. It's stated clearly in the contract.
What about your opponent's argument that that issue didn't get raised until after the case management conference?
Again,
therefore was waived.
What controls is the Federal Arbitration Act, because that's what's clearly deemed to be controlled in the terms of the contract for arbitration. And the language within this particular arbitration agreement listed a lot of different items that you can go ahead and engage in, and the court can't substitute its procedure for that which the parties have agreed in the contract.
Court's bound by precedent. There's precedent that says if you don't raise arbitration out of the gate, you waive it.
That's not the arbitrability. If you go to the recent Airbnb case,
this isn't an issue about who decides. This is an issue about whether or not arbitration is waived.
but it's not waived when, in fact, even the court below, and it's alleged in the motion for reconsideration of that motion to compel arbitration. He had even said, it looks like based on this could be raised anytime. Okay, and so that's what the actual term within the contract for arbitration was, that it could be raised anytime. So there's no waiver allowed by the parties, and if that particular argument is to be advanced, it would be an arbitrator who would make that determination. But candidly, I did find a case, a Swift case. It's not cited, but it does hold for the proposition that under certain circumstances, it could be seeking affirmative relief to ask for arbitration. But that's not, in this case, it was a defensive measure because the court had refused to do the initial analysis about whether there was even proper service to effectuate personal jurisdiction.
Almost out of your time, I just want to make sure that my understanding is correct. Your client filed a notice of appearance. And then a couple days later filed a motion to continue a hearing.
No, it was all done Friday before the Monday hearing.
Well, it looks like one was filed August 6th, one was filed August 9th.
Well, that may be, they were filed at 2 different hours on Friday before the Monday hearing, Judge.
But those were the first 2 filings.
That's right.
And neither of those asserted either a special appearance in order to contest jurisdiction or that there was a defect in service.
Right. And in the papers, there's citations to authority that clearly state that the notice of.
No, that's fine. I just want to make sure I have the sequence correct.
Yes, sir.
If you want to reserve your 5 minutes, now's the time.
Yes, sir.
Thank you.
Jesse Buckley on behalf of plaintiff in the underlying action, the appellee. As to the first issue raised on the appeal, I believe that the court does not have jurisdiction to entertain an interlocutory
Yeah,
appeal.
talk a little bit louder, unless it's me, thank you.
Yes, Your Honor. I don't believe the court has jurisdiction to entertain the issue regarding jurisdiction with regard to the personal service and personal jurisdiction below. Rule 9.130 contemplates providing this court with interlocutory review of an order determining jurisdiction over the person. Here, there were at least 4 or 5 prior orders that determined jurisdiction over the defendant in this action. So the order that is subject to the appeal is not the order determining jurisdiction. So we believe that it would be improper for this court to entertain that issue, and the court should simply recognize it doesn't have jurisdiction over that matter. If the court believes that it does have jurisdiction to entertain that issue, we believe that the trial court was absolutely within its discretion to find waiver. And that review of the record shows, as Judge Silverman just mentioned, the first action of the defendant were to file a general appearance and file a motion asking for leave to file an answering counterclaim. Defense counsel then appeared at the trial that was set that Monday. They have not provided a transcript of that trial, so we don't know what was said on the record, but clearly appearing at the trial and requesting leave to file a counterclaim could very well be seen as grounds for the trial court to say, you've appeared. There was nothing raised. And there's no argument presented by the appellant that they didn't waive their defects by appearing at trial. That was the first time they appeared. So we have an issue where the first actions taken by the defendant were general appearances in requesting relief, requesting the ability to have a trial on the merits and to assert claims against the plaintiff. That is entirely inconsistent with contesting personal jurisdiction.
But whether there was a default or not, your argument is the same, or does a default enhance your argument?
I think it enhances the argument. I think the issue, Your Honor, is the proper thing to do is if you're the defendant, you believe you've been improperly served, the first thing you do is you file a special appearance and contest jurisdiction. Then, if you, for some reason, lose that, you either take it up immediately on interlocutory review, which is why Rule 9.130 allows that, or you're stuck with that and you have to take appropriate actions below. Neither of those happened here. Instead, what happened was we had a general appearance and several actions, not just one filing, but 2 separate filings, and then an appearance by counsel before the defendant at trial. Now that trial did get continued, but we don't have a record, and we point out without a record, they can't even meet their burden to show why could the trial court not find that something the defendant or their counsel said at trial waived the defect in service. We don't know. We're bereft of the record of that hearing. So that's, I think if you are inclined to go into the merits of it, the first thing you have to recognize is that the trial court clearly can find waiver. And whether there was a defect in service, and this is one of the issues that we consistently argued below, and that has continued to be argued in the briefs in this case, is this distinction between you can have a defect in service that renders service irregular, which is essentially what has been argued. They said we didn't file an appropriate affidavit within the time period required. If that's true, that doesn't negate the entire case. The law is that renders service as, it makes it irregular, it makes it voidable, but it is incumbent upon the defendant to raise that at the first opportunity. And failing to do so waives that argument. Entering a general appearance waives that argument. So one of the distinctions we've constantly had is, okay, if there was an irregularity in service, that isn't the end of the story. Let's just stop and we don't have to look at anything else. It's always been, okay, let's look at what the defendant did. And so the first issue we have, aside from the jurisdictional issue in this court, is that there's clear grounds for the court to have found a waiver occurred. Also, even if this court had jurisdiction to review the most recent order entered by the court that's subject to appeal, given that we have a succession of prior orders, including ones making findings of waiver, and those were not appealed, and they're not attacked in the briefs, well then, for purposes of what we're here for today, the appellant has conceded the validity of those prior orders and the correctness of those rulings. Attacking a subsequent ruling, but there's prior rulings making findings of waiver makes no sense.
One question I would ask you is, opposing counsel has argued that following the notice of appearance, following the motion to continue, motion to abate discovery, none of them request affirmative relief. Do you have a response to the argument that affirmative relief, specific affirmative relief, such as actually a counterclaim, would have to be requested before an appearance can be deemed a general appearance?
Your Honor, I tried looking into that specific issue. I couldn't find anything directly dealing with the type of request made here. I've seen cases saying a pure motion to continue generally is not a general appearance. However, here we don't have just a motion to continue. We have a specific request to file a counterclaim. That was the relief requested. And I think what takes us out of the zone of uncertainty is that we also have an appearance at an evidentiary hearing, a scheduled trial by the defendant. And there's no record that the defendant preserved any kind of jurisdictional argument at that appearance. We're left with a blank slate where clearly their conduct can constitute waiver. With regard to the issue of the arbitration motion, I think it's interesting because defendant appellant now acknowledges that there is case law suggesting filing a motion to compel arbitration could be seen as affirmative relief, and clearly they did that here. Now, it was untimely. It was raised 11 months after the defendant knew about the lawsuit, 8 months after defense counsel appeared, after numerous motions were filed, after motions for rehearing were filed, and significantly, there was a time when the court set a case management conference with a very detailed notice of what would be addressed at that case management conference, including all issues of fact to be decided before trial, all legal issues to be decided before trial, and any issues regarding alternative dispute resolution, which arbitration is. None of these issues were raised at that case management conference. The defendant had nothing to add, had no issues that were brought up at that case management conference, and so the judge set it for trial. And it was only on the eve of what I believe was the 6th time the case was set for trial, because it kept getting continued due to these successive motions, and we unfortunately had 3 or 4 judges that rotated during about a year and a half on the bench. Case got set for trial 5 or 6 times. On the eve of the last trial, the motion to compel arbitration was filed. And at that time, the court said, look, this case has been set for trial numerous times. We've had numerous hearings. We had a case management conference where you were advised that you had to bring to my attention any of these issues. You didn't bring them to my attention. This issue has been waived. And that is not de novo review. That is an abuse of discretion review. And clearly, the record fully supports the trial court's exercise of discretion in saying that the arbitration issue was waived. Unless the court has any further questions for me, I'll rest on it. Thank you.
The first point would be the allegation that we somehow appeared in a trial. That is just not the case. The motion to continue was what was heard. There's no evidence to the contrary that there was ever any initiation of the trial proceeding. The relief that was sought was basically for an extension of time to review the case and determine what needs to be
When you
done.
say the relief that was, sorry, you're talking about what happened in this untranscribed proceeding?
No, I'm talking about what was requested in the motion to
Right.
continue. That's what I'm saying. That was, in other words, there was no, and it was not a general appearance that was the notice of appearance. The
Thomas Whitaker hereby enters this appearance on behalf of defendant Wendy's in the above styled cause and requests all future pleadings, notices, and correspondence be served upon counsel at the address below. Is there any indication that that is a limited appearance in which to challenge jurisdiction?
well, let's do it the other way. There's case law.
I'm reading your language.
I understand, but that's not what is meant. It's a term of art. And
I understand what a term of art is, and I understand what a term of art is when someone files a special appearance in order to challenge jurisdiction. Does your notice of appearance indicate anything to that effect?
There was actually a discussion in one of the cases in the cited in the paper that the attorney put in his notice that it was a general appearance, but they said that doesn't control. In other words, he's got to actually be seeking some type of affirmative relief in addition to saying, hey, I'm in the case, please send me copies of the pleadings. Okay, I will cite the court, it was contained in the motion to continue what was styled originally as a case management conference, but it was continued. There was a new judge too. So one of the things that I included in that motion, and that this is actually found at our appendix 352. And I characterize it as a palpable error in the recent order. And it was, the court included the language of Wendy weighed insufficiency of process and insufficiency of service of process by filing a general appearance on August 6, 2021, which I believe Judge Silverman you just read from, included the notice of appearance and filing a motion to continue hearing, which was Wendy's first motion in the case, and which failed to set forth any arguments regarding insufficient service or service of process. By failing to set forth any arguments pursuant to the Florida Rule of Civil Procedure 1.140B, Wendy's motion constituted a general appearance and a waiver of any defects in service. The court cited to a first DCA case and a fourth DCA case, but what the court did not cite to was the second district court of appeal case, D. Giovanni, at 83 Southern 3rd, 934 from 2012. And I quote from that, however, the filing of a notice of appearance by defendant's counsel did not waive defendant's right to claim lack of jurisdiction over his person. Citing to Public Gas Company, Florida Supreme Court case of 1982 at 409 Southern 2nd, 1026. Furthermore, a motion for extension of time does not constitute a general appearance. Citing Barrios, which is 456, 590 at Southern 2nd from the third DCA. So the true issue was never entertained at the trial level about did substitute of service take place. And if not, then there's no service and there's no personal jurisdiction. The successive orders. Again, there is nothing in any of the police papers, no authority dealing with substitute service situation. Matter of fact, one of the main cases cited.
Mr. Richard, just let you know, you're at the end of your time. You can take 30 seconds to wrap up.
Okay. The way I started the brief is the way I ended. In both cases, both issues, cart was put before the horse. And the requisite showing compliance, strict compliance was not, and that's why there was never service. And in terms of the arbitration, the duty is to show a defect in the contract itself. That never was done. These are both burdens on the employment. Thank you again for your time.
Very good. Thank you both. The next case is Encompass Health versus Shoemaker.